Topic 6 is about employee rights and duties. At the end of this particular topic, students should be able to understand human rights and employee rights, discuss the importance of workplace snooping and drug testing in employment, and will be able to explain the role of whistleblowers. Workplaces are like second homes to most employees. Almost 1/3 of their lifetime is spent on employment. Modern workplaces have many facilities and infrastructure to provide for their employees. This is mainly because of the capability and the legal rules. When groups of individuals come together and spend quality time with their common goals, many ethical and legal issues come up. This is mainly because the employees are from different backgrounds, thoughts, and beliefs. Globalization has paved way for employees to commute between countries for better prospects. And so, a cultural diversity is found in almost all organizations, and when people from different ethnic backgrounds work together, difference of opinions, viewpoints, and skills may hinder growth and harmony. There should be basic awareness of law of the land, appreciate these laws, understand the rights as individuals and employees to work within the framework. Such knowledge should be self-acquired by the employee and also provided by the employer through employee manuals. An employer should remember that when workplace snooping and drug testing are justified, and if the activities are ethical and legal, whistleblowers will not surface. The work environment will be conducive and employees can be typically called as a resource than to mention specifically human resource. What are human rights? Rights are entitlements by virtue of which one person justifiably lays claim to an object or state of being against another person, who has a right to respect that claim. A right can also be defined as a capacity, possession, or condition of existence which entitles either an individual or group to the enjoyment of some object or state of being. Example, the right to free speech is a condition of existence which entitles one person to express one's thoughts as one sees fit. Rights can be for the freedom of speech and assembly, property ownership, equal treatment, education and basic medical care, privacy, etc. In political, social, and personal interactions, there are many cases in which rights seem to conflict. Example, one person's right to free speech may conflict with another person's right of privacy. Hence, the assertion of right should always be given due consideration. Or, one right can be overridden by another in special cases. The general rule is that since rights protect interests, when one person's rights are stronger or more compelling than another's, then rights to the latter can be justifiably overridden by rights to the former. Human rights are the natural rights of the citizens to life, liberty, and property, and hence these rights are absolute, unalienable, and universal. Now let's move on to employee rights. Legal rights of employees are simply those that exist through legislation or government regulations. Some specific rights can be discussed as follows. Right to work. This is providing equal opportunities to attain the job without discrimination. Right to meaningful work. A moral claim that tedious, repetitive, and boring work is dehumanizing. Once hired, an employee certainly can claim rights such as right to safe and healthy work environment, right to job security and due process in firing and promoting, right to privacy, right to compensation for injury, right to participation or voice in matters affecting workers, right to equal treatment without regard to race or gender, right to pension protection, rights to collective bargaining such as those established by the National Labour Relations Board, right to free movement from harassment, right to a living wage. Workers possess rights as human beings and their rights impose special standards at the workplace. For example, law prescribes that the right to occupational safety is when prospective employees appear and are made aware of the type of job being offered and its hazard they are at liberty to accept or reject, organize into groups and insist on various terms not in the offing, bargain alone or together with others, and set terms that include improvements or pool workers' resources, borrow and purchase the firm. What is workplace snooping? The question of monitoring employee activities at workplace is considered as workplace snooping, and it is both legal and ethical. The hike in employee salaries and corporate liability for employee actions give justification for the employers to be interested at least in what their workers are doing. Employees have a significant interest in maintaining privacy over important information about themselves, and so employees must be recognized as having a right to privacy. An employer may also be justified in wanting to identify the culprits when a firm finds itself the subject of pilferage or employee theft. To balance these three issues, three elements must be considered when collecting information that may threaten the employee's rights to privacy. The first element is the relevance. The employer must limit inquiry into the employee's affairs to those areas that are directly relevant to the issue at hand. The second one is consent. Employees must be given the opportunity to give or withhold their consent before the private aspects of their lives are investigated. And the third are the methods. The employer must distinguish between the methods of investigations that are both ordinary and reasonable, like normal supervisory activities, and extraordinary devices like microphones, secret cameras, etc. Technological developments have given rise to more monitoring of employees. Computer monitoring is required to prevent downloading, copyright protection material, access to hackers and viruses, misuse of firms' letterhead, and leak of trade secrets. The guidelines to be adopted are: there should be no monitoring in highly private areas such as restrooms. Monitoring should be limited to the workplace. Employees should have full access to any information gathered through monitoring. Continuous monitoring should be banned. All forms of secret monitoring should be banned. Employees should always be given advance notice of monitoring. Only information relevant to the job should be collected. Monitoring should result in the attainment of some business interest. Drug testing is another way an employer can interfere into the privacy of an employee. But is drug testing in employment justifiable? What is it? It means obtaining information about an employee, whether he uses drugs or not. The information sought must be relevant to the contract in order for the drug testing should not violate privacy. Hence, it must be decided if knowledge of drug use obtained by drug testing is job relevant. In cases where the knowledge of drug use is not relevant, there appears to be no justification for subjecting employees to drug test. In case it is job relevant, then when and under what conditions it is justified should be focused. Knowledge of drug use should be job relevant because drug use adversely affects job performance and in turn has the following impact: lower productivity, higher costs, and lower profits. Use of drugs by an employee can also affect the employee himself, the fellow employees, employer, and third parties like consumers. Knowledge of drug use is to prevent harm. Some jobs like airline pilots, school bus drivers, surgeons can create potential harm if the concerned professionals abuse drugs. Some jobs like accountants, professors, administrators may affect their job qualities in an indirect way when they use drugs. Hence, nature of job is important to make drug testing, and not every person is to be drug tested. The limitations to drug testing policies would be to protect innocent employees from harm of losing job and reputation, obtain consent of the employee before drug testing. Prior notice of testing would give employee option of freely refraining from drug use. Employees should be notified the result and also allowed to appeal for results, and the information should be kept confidential. Whistleblowing. Now, whistleblowing at a workplace. What is it all about? It is an attempt by a member or former member of an organization to disclose wrongdoing in or by the organization. It can be internal or external. If the wrongdoing is reported only to those higher in the organization, it is internal whistleblowing. When wrongdoing is reported to external individuals or bodies such as government, agencies, newspapers or public interest groups, the whistleblowing is said to be external. Whistleblowing is morally justified if there is clear, substantial and reasonably comprehensive evidence that the organization is engaged in some activity that is seriously wrong. If reasonably serious, attempts to prevent the wrong through internal whistleblowing have been tried and have failed. If it is reasonably certain that external whistleblowing will prevent the wrong, if the wrong is serious enough to justify the injuries that external whistleblowing will probably inflict on oneself, one's family, and other parties. Factors to be considered in whistleblowing. Make sure the situation is one that warrants whistleblowing. Examine the motives. Verify and document the information. Determine the type of wrongdoing involved and to whom it should be reported. State the allegations in an appropriate way. Stick to the facts. Decide whether the whistleblowing should be internal or external. Decide whether the whistleblowing should be open or anonymous. Decide whether current or alumni whistleblowing is required. Make sure to follow proper guidelines in reporting the wrongdoing. Consult a lawyer. Anticipate and document retaliation. Now, what is beyond whistleblowing? To eliminate the wrongdoing which gives rise to whistleblowing, give whistleblowers greater legal protection. To change the nature of organizations so as to diminish the need for whistleblowing, these solutions are not mutually exclusive, and laws protecting whistleblowers have been opposed on the grounds employees would use them to mask poor performance, they would create an informer ethos, and they would also take away the autonomy of business, strangling it in red tape. Thus, a workplace should be managed efficiently, free from conflicts of rights of individuals and employees, and control the situations like workplace snooping, drug testing, and handling whistleblowers as and when they arise, so as to justify the actions and do such acts within the framework of ethical and legal boundaries. To come across certain live examples, the first one, it was found that one organization received a legal notice asking for a huge financial compensation for defamation and invasion of privacy. When investigations were made, one employee was identified to have sent unwanted defaming emails to various people during his lunch break using the office computer. After having paid the compensation, the company sacked the employee and also took legal action against him. For no fault of it, the company made a heavy loss. Under these circumstances, it is justified to conduct workplace snooping on employees. The second one is that an employee under the influence of alcohol or drugs will be shown in poor light when he meets with customers and suppliers. Such inappropriate representations will affect quality of work and reputation of an organization. If the employee is operating near dangerous machinery, drives or handles hazardous materials, he will even endanger others' lives, and if he is a drug addict. So, drug testing on employee is definitely job relevant. Thirdly, on whistleblowing, it is a belief that to prevent external whistleblowing, one should encourage internal whistleblowing. So, avoiding unethical and illegal practices in business does not create whistleblowers. So, this would be the end of topic 6. And we will have to move on to chapter 7. Thank you.